This Honorable Court of Tennessee is now in session.
Good afternoon. Before we call the case, just one thought. If we don't anticipate any technology-related problems, but if we should have any, everybody just take a deep breath and we'll pause and work through it. Madam Clerk, will you call the case, please?
GT Issa Construction, LLC versus Bonnie Blaylock.
We'll hear from the appellant.
Thank you, Your Honor. May it please the court, my name is Terrence Jones of Chattanooga Bar, and I represent the appellant GT Issa Construction, LLC. I've reserved 5 minutes for rebuttal time.
Yes.
Your Honors, the case that we present to you today is about stone veneer and fescue sod. On its surface, the case seems very straightforward. Ms. Blaylock complains that my client, GT Issa Construction, failed to cover a retaining wall installed on her property with brick or stone veneer, and she complains that her yard was sodded in Bermuda grass rather than fescue as she desired. The contract in question involves the building of a custom home for Ms. Blaylock. The problem, and one of the two real cruxes of our case today, is that the contract's plain terms include no obligation or requirement on my client to install any covering on any retaining wall, and no requirement that he use fescue sod or any particular type of sod. To be clear, there is no argument and no evidence presented at the trial of this case that the quality of the workmanship of the home was substandard, or that the wall was substandard, or that the installation of the sod in the yard was substandard. The complaint is simply she didn't get brick or stone veneer on her wall, and she didn't get fescue sod. But she did not contract for those items. She did not pay for those items. And she was not owed those items. In the face of these facts, a jury is awarded damages for breach of contract and breach of duty of good faith and fair dealing at the trial of this case. And this naturally begs the question, how did the jury get it wrong? Well, as we briefed, the jury got this wrong because of a series of decisions made by the trial court that allowed the jury to be biased in favor of the plaintiff. Most of those I'm going to leave to the briefing just in the interest of time today, but we would like to focus on a couple of things. First, in this case, in the trial of this matter, the trial court allowed for Blaylock's expert to testify that the phrase good and marketable title, subject only to subdivision and condominium declarations from paragraph 5 of the Tennessee Association of Realtors real estate purchase contract should be read instead, good and marketable title in compliance with the real covenants and declarations. It's GT Issa's position that this testimony is clearly parole evidence, which is being used to alter the terms of what is at least a partially integrated contract. In Individual Healthcare Specialist versus Blue Cross Blue Shield, the Supreme Court went out of its way to reaffirm that contextual evidence may not be used to vary, contradict, or supplement the contractual terms in violation of the parole evidence rule. But that's exactly what the expert testimony was intended to do. Paragraph 5 of the Tennessee Association of Realtors contract has nothing to do with the physical condition of the property or its physical attributes. Instead, it's a statement regarding the quality of title that is to be granted from my client, GT Issa, to Blaylock at the closing of the transaction. Paragraph 5A says that when Blaylock gets her title, she will not be free to do whatever she wants with her property, but instead her ownership rights will be limited by the things that are listed in the paragraph: zoning ordinances, setback requirements, subdivision declarations, and other things. To refer back to the old bundle of sticks analogy of property ownership, if each of her rights are sticks in a bundle, then subject to means she's missing certain of those sticks, and that she will accept title to the property with those limitations in place. By changing the term subject only to in compliance with, Blaylock has fundamentally changed the purpose of paragraph 5 from a limitation on the quality of title that she will receive to a warranty regarding the physical characteristics of the property that she's purchasing. It flies in the face of the parole evidence rule and should not be permitted. And by allowing Blaylock's expert to testify as he did, the trial court allowed the jury to be tainted by evidence it should not have received. And how do we know that this was to GT Issa's detriment? Well, because without the mental gymnastics that are required to rewrite paragraph 5A in this way, there's no basis in the contract for finding that Issa was obligated to cover the wall with anything. And this is even more true where Ms. Blaylock withdrew her implied warranty of compliance with covenants claim before it went to the jury. Now, the trial court didn't stop there, but doubled down on this impermissible evidence when it allowed Blaylock's expert to testify that the standard exceptions that are found on the title policy as contemplated by the contract has a special and arcane meaning that only a person who's been in the industry for decades would understand, rather than the usual use of the word standard, which would mean something like those exceptions that a person would expect to see in most cases. Blaylock's expert testified that standard exceptions are only the exceptions that appeared on pre-printed forms for title insurance commitments in the days before each commitment was prepared by a computer individually. Now, no one had testified that either GT Issa or Blaylock had any knowledge of this arcane meaning at the trial. And the Supreme Court, back in the Blue Cross and Blue Shield case, stated that the extrinsic evidence of context can be used to interpret the contractual language in line with the party's intent. The Supreme Court also quoted the Supreme Court of Texas that said the evidence may only give words of a contract a meaning that is consistent with that to which they are reasonably susceptible. So how can information, which can only be known to a title attorney with 25 years of experience, affect the intent of these parties? Again, Blaylock's extrinsic evidence goes much farther than Blue Cross and Blue Shield allows and shouldn't have been allowed at the trial. It tainted the jury, and because of that, the jury received no true admissible evidence that my client was obligated to cover this wall or to install fescue sod. As a result, the court should have granted our motion for directed verdict following the trial. Briefly, I'll address the good faith and fair dealing claim. In Dick Broadcasting versus Oak Ridge FM, the Tennessee Supreme Court stated that the duty of good faith and fair dealing requires that neither party shall do anything which will have the effect of destroying or injuring the right of the other party to receive the fruits of the contract. Again, in this case, the fruits of the contract was a custom home, and Ms. Blaylock received that at the closing. GT Issa built it for her. She had no complaints that she failed to receive anything that was actually included in the contract, only these additional items that she did not contract for, did not pay for, and was not owed. Now, in the interest of time, we'll leave the other trial assignments of error to our briefing, but I would like to talk about the second main crux of our case today, which is assuming, for the sake of argument, that there were no errors during the trial. We believe that the award of attorney's fees is an error. And the reason we believe that is this court, in May of 2020, just days before our trial court issued its opinion on the attorney's fees, this court issued the opinion in Tennessee State Bank versus Moshek. Now, in that case, Tennessee State Bank sued its borrowers, the Mosheks, in a multi-count lawsuit, which alleged breach of a promissory note, declaratory judgment regarding a deed of trust that secured that promissory note, and reformation of the deed of trust that was an alternative claim. Ultimately, the bank only was successful on its promissory note. And on appeal, this court remanded that case for consideration of or a determination of the amount of the reasonable attorney's fees and expenses incurred by the bank solely related to the enforcement of the note and apart from the reformation action. Now, this argument very closely mirrors our argument in opposition to the original motion for fees. And that is, Blaylock, like the bank, filed a multi-count lawsuit against GT Issa Construction. And she was successful on only really one of her claims, breach of contract, which includes the breach of good faith and fair dealing. Now, because she was successful on less than all of her claims, she has expended, obviously, money and attorney time in pursuing those claims. But those other claims, standing alone, would not justify an award of attorney's fees. For example, if the jury had returned a verdict for fraud only and nothing else, then we wouldn't be talking about attorney's fees today. Likewise, if she brought only the Tennessee Consumer Protection Act claim standing alone, and that had failed as it did in this case, she wouldn't receive any attorney's fees for that claim. So it seems to us there is no logical reason why she should be permitted to file what amounted to ineffective claims, expend time, and then collect it simply because the one thing that she was successful with had an attorney fee provision in it. Now, when we made this argument below, the trial court rejected that argument and stated in its order that that the various claims in this case were based on the same set of operative facts and arose out of the same transaction. That's also error. The court in Moshek ruled that there was seemingly a difference between claims related to a promissory note and the deed of trust that secured the same note. We can't conceive of two claims that would be more closely related to the same operative facts or arise out of the same transaction more than a note and a security instrument that secures that same note, especially when those documents are executed on the same day and in connection with the same transaction. Now, Given the similarities to the two cases, we believe that the precedent of Moshek should be applied to this case. That is, there's a threshold question on attorney's fees. Are we awarding fees for claims that were not successful and would not have generated attorney's fees on their own had they been successful? And in this case, the answer is yes. Because she did not submit the proof that she needed to prove this issue, this differentiation, this court should deny or vacate the order for attorney's fees and remand this case with that instruction. Thank you, Your Honors. I reserve the rest of my time.
You have your time for rebuttal. We'll hear from the appellee.
Thank you.
Thank you, Your Honor. Nate Kennard of the Chattanooga Bar, representing the appellee, Bonnie Blaylock. This case is a perfect representation of the adage that you should be careful what you ask for because you just might get it. Ms. Blaylock, unhappy with certain issues with her home, filed a suit in General Sessions Court. She testified that whatever the General Sessions Court concluded, she would have stuck with. But Mr. Issa wasn't happy with that. The morning of the General Sessions trial, he filed a lawsuit in Circuit Court demanding a jury. He did not only sought a declaratory judgment action about the meaning of the contract between him and Ms. Blaylock, he also brought claims for fraud, misrepresentation, malicious prosecution, and he sought punitive damages. As he testified himself, he did it because he wanted to step it up several notches. He did it because he was upset. And he admitted that this was why the parties were still fighting 2 years later. As the trial court found below that Ms. Blaylock was not willing to, she wanted to prove a point that she couldn't be bullied by Mr. Issa. And that's the point of having a prevailing party provision in a contract between two parties, that the one party that has more resources can't just use the hammer weight of litigation fees to keep themselves from being proved wrong in court. And ultimately, that's what happened. The jury found in favor of Ms. Blaylock. And on the question of attorney's fees, the trial court found in favor of Ms. Blaylock. Those two critical things color nearly everything that this court has to do. The standard of review is favorable to Ms. Blaylock on all factual questions. I want to start on this issue of attorney's fees and then turn to some of these issues of contract interpretation and construction. The first thing is that opposing counsel has said that the trial court erred by finding that Ms. Blaylock's claims were all closely related, but on page 33 of their opening brief, opposing counsel said her claims were, quote, clearly related. I mean, it's an out and out concession in the brief. More important,
they win on the consumer protection issue.
Ms. Blaylock did not succeed on the consumer protection issue, Your Honor. She succeeded on two claims, breach of contract and duty of good faith and fair dealing, which is really subsumed within the breach of contract argument. And the trial court acknowledged that Ms. Blaylock did not succeed on all of the theories that were presented to the jury, but said that you can't deny attorney's fees that were expended in pursuit of one claim if they were also pursued in pursuit of a successful claim. And that's what happened.
But if they succeeded on the consumer protection issue, were they not entitled to attorney fees on that?
No, Your Honor, that requires the claim to have been frivolous under the TCPA, and Issa made that argument below and was unsuccessful. The trial court said this claim was not clearly frivolous, and that issue has not been appealed. So it is not before the court. Importantly, this case is really identical to a very recent case from the Sixth Circuit, Cook versus Greenleaf Township. In that case, the Sixth Circuit was presented with a defendant that had lost below. The damages were found to be $500, 500, less than $1,000, and the trial court awarded over $137,000 in attorney's fees. And the Sixth Circuit said this: these defendants simply assert that the attorney's fees must have included unrelated work without challenging any specific billing entry or citing any supporting facts. The court nonetheless found in favor of the plaintiff in that case, say, in spite of the, quote, gargantuan attorney's fees award. Why? Because you're in a different context on appeal than you are before the trial court. On appeal, if the trial court has found that claims are clearly related to one another, if they arise from the same common core of operative facts, that is a factual finding reviewed for clear error. And in our case, the trial court made exactly that finding. So,
Counsel, explain to me, what is ambiguous about this contract?
yes, Your Honor, a couple things. First, the phrase subject only to, I submit it's fairly opaque, exactly what it's supposed to mean. And we've got.
And as you explained this to me, did the judge charge the jury that the contract was ambiguous? And did she make a finding that it was ambiguous?
Yes, Your Honor. She said this contract is ambiguous, so you may consider extrinsic evidence. Now,
She didn't say why, or did she say why?
I do not believe that she told the jury any details about why she concluded it was ambiguous. She just said it was ambiguous, and so if you would like, you can consider extrinsic evidence. But of course, the jury was perfectly free to accept the interpretation put forward by Issa. They just didn't think it was the best interpretation of the contract. Also, the phrase standard.
Get everything she sued for?
No, she did not. She did seek more damages than she was ultimately awarded. She was awarded $6,800 as well as over $5,000 in costs and expenses.
How much did she sue for? How much was actually presented to the jury as far as what she sued for?
Approximately $1,700, $1,800, or excuse me, $17,000, $18,000 if you added it all together. Wasn't specified in the complaint, Your Honor.
So the percentage of her recovery was how much?
If you subtract the costs, it's about a third. If you include the costs, which were naturally a cost that Ms. Blaylock had to pay, it would be about 60, 70%. Another aspect of this contract that's ambiguous is the phrase standard exceptions. I don't know exactly how you define standard exceptions, except by looking to industry and trade usage. Opposing counsel has said that, has said there's no evidence that Mr. Issa knew about any sort of industry usage, but he actually owns a title company. The title company that was used in this case, Warranty Title. He can't be said to be some sort of naïve in connection with industry usage. And the testimony of Mr. Copay is, I think, quite overwhelming. Certainly plenty for the jury to agree upon that the phrase standard exceptions only means the first 5 pre-printed exceptions that appear on every warranty policy. And it's undisputed in this case that the title policy in this case included more than 5 pre-printed exceptions. That's another important ambiguity. And another really important one, Your Honor, is that this contract is not fully integrated. It does have an integration clause, but on its face, it rebuts the accuracy of that integration clause. And this is critically important. The contract says in these special stipulations, which I believe are paragraph 19 of the contract, that it incorporates addendum 1. And it also says that the contract is to be built in accordance with the GTI 419-118 parentheses modified plan. Now, this addendum 1 to the contract repeatedly refers to changes that were made in this GTI 419 plan. I would point the court to appendix page 17, where on 3 places it says that there are changes to this plan that are, quote, noted in file or noted on file plans. Now you look through this, the record, you won't see any plans and specifications. You won't see any architectural drawings. You won't see the things that guided how the house was actually built. Why? Because Mr. Issa, quote, threw it away. He threw away the plans and specifications. And importantly, they're not attached to this contract. The central document that actually defines how this house is supposed to be built is not attached, and it's missing. It did exist. But
how the house is supposed to be built, aren't we just talking about the veneering around the wall?
Yes, but plans and specifications are incredibly detailed. They would presumably include that, but potentially if they didn't, that would also be relevant, but we don't have it. Mr. Issa threw it away. Anything related to the construction of a home is going to be included in plans and specifications. That's how the workers know what to do. I think what's critical about the absence of these plans and specifications, this GTI 419 plan that did exist, is that it is not included in this contract. It is incorporated, but it is not included. It's missing. This contract cannot be fully integrated if a critically important document has been thrown away, is gone, and is not actually made a part of the agreement. That is the crux of being a fully integrated document, that it is complete in and of itself. But we don't have the plans and specifications. It cannot be complete in and of itself. That means what we're left with is a partially integrated document. We're left with a document which, under the parallel evidence rule, can be supplemented by consistent additional terms. What's super important here, Your Honors, is that every single employee of GT Issa Construction Company that testified, and this includes Mr. Issa himself, the president, and I think chief manager is, I think, his title, as well as his COO. The COO of the defendant said that a builder of new construction has to build in compliance with restrictive covenants. Now, this is a compelling piece of evidence if, all of the parties that testify in behalf of Issa at trial admit the question at hand. But opposing counsel tried to confuse the issue somewhat in the reply brief. Now, there are 2 points at which Mr. Issa made this concession on the stand. First, at appendix page 81, he was asked, Mr. Issa, as a builder of new home construction, do you believe that you are obligated to, and I omit a phrase, you are obligated to follow subdivision requirements that are acknowledged in your deeds, that are acknowledged in your purchase and sale agreements? Are you required to follow those subdivision restrictions? And he said, I am.
Now, did your client pay for that additional work then?
But it's a fixed price contract. So yes, as Mr. Copay testified, compliance.
Is that a part of the contract?
Well, we would say yes. 1, because it's agreed to by all the parties. 2, because it's a reasonable implied term. 3, because paragraph 5A requires to be built subject only to, which means in compliance with, according to testimony of a reliable expert witness. And 4, because the home has to be conveyed with good and marketable title pursuant to a very specific definition provided in the contract, which relates to this question of subdivision restrictions.
Counsel, let's go back to paragraph 5A there.
Yes, Your Honor.
Seller warrants, the seller will convey good marketable title to said property subject only to, subject to zoning. Doesn't that mean that whatever the zoning requirements are affecting your client's property, they apply?
I think what this means, Your Honor, is that it has to comply with the zoning requirements in this context. And I would refer the court.
Not that it has to comply with them. What about an easement? How does it have to comply with an easement?
Well, if the terms of an easement are somehow inconsistent with the construction, as it was constructed by Mr. Issa, say it violates some pre-existing easement, then that would be a similar problem, Your Honor.
You're saying it doesn't apply. What it isn't saying is telling the seller or the buyer, okay, you get good marketable title, but there might be an easement there. I think the property will be subject to that.
I think it can mean that. I think it can also mean that it has to comply with any such documents. And I don't think here's the problem. The problem is not that it's really clear one way or the other, Your Honor. I think it's ambiguous. It's unclear. And so the jury was entitled to consider extrinsic evidence to help identify what the parties meant. That would include very compelling evidence of practical construction. So after the contract was entered into, Ms. Blaylock met with Emily Smith, now the COO, and asked about this retaining wall. So the home is under construction, the contract is being performed, and asked, is this wall going to have, brick or stone on it? And she asks Mr. Issa, who's right there, she says, is it going to have brick on it? And he says, yes. And he also quoted a price if it was going to be put in stone, because it wouldn't cost anything extra if it was going to be veneered and brick. But if it was going to be stone, it would be extra. So that's incredibly important evidence of practical construction, which the Tennessee Supreme Court has said is They've described it as some of the best possible evidence of the party's meaning. I think some of the safest evidence of the party's meaning is what the Tennessee Supreme Court said in individual healthcare services, quoting from Staub v. Hampton, I believe. I want to transition to one last point in connection with our attorney's fees on appeal. The recent case of Milan Supply Chain, the court presented with a request for attorney's fees on appeal in connection with a TCPA claim, said, we're going to go ahead and grant your attorney's fees on appeal because, quote, the rationale supporting fees in the trial court carries over and supports the defense of the award on appeal. Submit that's the situation presented here and that the trial court's judgment should be affirmed. Thank you, Your Honors, unless you have any further questions.
I hear none. We'll hear from the appellant rebuttal.
Sorry, Your Honors. Your Honor, in rebuttal, I'd like to touch on a few points. First is, over and again in this case, Blaylock has attempted and been permitted to rephrase the issues from what they are to what she wishes they would be. The biggest single example of this is the testimony of her expert witness, which completely changes the outcome of paragraph 5. We've talked about that at length. Again, we hear another statement of a rephrasing of the facts. Mr. Issa does not own a title company, to my knowledge, never has. He's a custom home builder. So to charge him with knowledge of a title industry professional is simply not appropriate. And now on appeal, Ms. Blaylock again attempts to rephrase the issues and control, again, the consideration of this court with its arguments, with her arguments. We're not here arguing that the jury received all the evidence and simply made a wrong decision. We're arguing that the jury was tainted because it received inadmissible evidence in a way that was detrimental to GT Issa Construction. Now, the second issue we'd like to touch on is there's several misstatements of the case law in this case. For example, in her brief, Blaylock states that, quote, there is an implied duty under the law to build in conformity with building codes and subdivision restrictions. That's simply not true, and it's never been held in any court in Tennessee of which I'm aware. For this proposition, Blaylock cites Carter versus Kruger, and that case says that the implied warranty to build in a workmanlike manner includes an obligation to build in conformity with the applicable building codes, but it does not mention restricted covenants. Now, Blaylock bridges this gap by simply saying there is no logical difference between building codes and covenants, but this is patently untrue. Building codes are law. They're put in place by the state or the county government. They don't necessarily require the consent of the governed person. There's no obligation of mutuality or contract or agreement. Restricted covenants, on the other hand, they're creatures of contract. They take their authority from the title, the chain of title from their prior owners. The two things, building codes and restricted covenants, are subject to different defenses. So they're not the same. And simply saying that they are doesn't get us there. It's not law in Tennessee that there is an implied warranty to build in compliance with subdivision restrictions.
Counsel, did your client testify about the builder's obligation as far as subdivision restrictions?
He did, Your Honor. He said that in general, builders need to build in compliance with the subdivision requirements. But he also testified that certain requirements are unenforceable because they've been abandoned. And there was testimony in the trial in this case that most of the walls that are in this subdivision, in this community, Majestic Hills in Chattanooga, Tennessee, are not compliant. That is, they are not covered in brick or stone veneer or stucco if the house is stucco.
All right, help me here. So was he saying that while, yes, the builder normally is required to build to satisfy subdivision restrictions, they didn't have to do that here as to the wall?
Correct, Your Honor.
Okay, so not disagreeing that it applied, he just says that it had been abandoned.
Well, I think we have 2 points on that, Your Honor. Yes. First, he didn't have to build this particular wall in compliance because this covenant had been abandoned. But second, and more importantly, the Blaylock did not sue on the covenant. She could have filed a lawsuit for breach of restricted covenant, and she didn't do that. Instead, she filed a breach of contract action and sought through this novel implied warranty or incorporation of the covenant through paragraph 5 to enforce the covenant against my client in that way. Had she filed a restricted covenant case, she would have been subject to the selective enforcement defense. And, she was seeking a way around that. Your Honors, I also wanted to point out briefly that Blaylock cites the Reed versus Wally Kennard construction case for the proposition that a home that's in violation of a neighborhood covenant has a defect in its title, and therefore that Issa did not grant good and marketable title. Reed versus Wally Kennard construction is a Tennessee Consumer Protection Act case. It's not a contract case. It's not subject to the same standards or the same law, and we believe it's inapposite to the outcome in this case. Finally, Blaylock makes a lot out of the fact that we haven't challenged the reasonableness of attorney's fees, but we did just that in our brief. And Blaylock wholly ignores the standards set out in the Mashek case. Your Honors, in conclusion, notwithstanding the complications added by Blaylock in this case, we believe it remains very straightforward. We would ask this court to vacate to reverse the trial court's decision on directed verdict, which necessarily vacates the attorney fee provision, or in the alternative, vacate the attorney fee provision or send it below for a determination of the fees solely expended on the breach of contract case. Thank you.
All right, court thanks counsel for both sides for your briefs and your oral argument. Madam Clerk, if you would please recess court till our next scheduled case.
This Honorable Court of Tennessee is now in recess until 2:30.
Thank you, Your Honors.